Good afternoon and welcome back to the Supreme Court of the United Kingdom. The court is currently hearing the submissions of Ms. Quinlivan. Ms. Quinlivan.
Thank you, my lord. My lords, I'd indicated that we had three topics to cover in relation to the common law: legitimate expectation, irrationality and independence. My lords, we've dealt with these topics in our written case, electronic pages 4161 to 4172. If I can refer your lordships in particular to the submissions that we've made in relation to legitimate expectation, they're electronic pages 4165 to 4170, paragraphs 91 to 98. And just to indicate that we are probably not going to develop the issue of legitimate expectation overly beyond that which we've touched on. We intend to deal more fully with rationality in the context of the police's investigation. But your lordships will have seen that the issue around legitimate expectation relates to the attendance by the Chief Constable or the Assistant Chief Constable at the Northern Ireland Policing Board. He had been asked a question by a member of the Northern Ireland Policing Board, and you can find that for your reference at electronic pages 3442, or indeed in our written case at 4148 to 4149. And it stated that following the assertion in official documents that Lord Carrington authorised the use of methods of torture in this jurisdiction, what action has the Chief Constable taken? And the response was that the PSNI will assess any allegation or emerging evidence of criminal behaviour from whatever quarter, with a view to substantiating such an allegation and identifying sufficient evidence to justify a prosecution and bringing people to court. My lords, in very short term, we say that created a legitimate expectation consistent with what the Court of Appeal said, was that there was an expectation that there would be some investigation as to whether criminality had occurred. We pray and aid the judgment of the Court of Appeal, which addresses this at electronic page 1924, paragraphs 112 to 113. And my lord, unless there's specific questions and relying on our written case, essentially the situation is that commitment has been made. That commitment hasn't been resiled from. In some senses, the question may arise as to where the benefit to the applicants are, in the sense that the commitment persists at the matter as matters stand, and in due course the issue will be, if the Chief Constable were to resile from that commitment, that would be a matter that the applicants would then be in a position to rely on. Mr. Justice Maguire looked at the issue somewhat differently. His view was that, and you'll find that in electronic page 2031, paragraph 314, his views that what the Chief Constable said amounted to little more than a statement of what was his duty, come what may. The Police Service for Northern Ireland and the Chief Constable in their submissions have referred your lordship to essentially what they say is that this is nothing more than a statement of the Chief Constable's duty under statute. They refer you, and I'll give it your lordships the reference, to section 32 of the Police Northern Ireland Act, and you will find that if you need to look at it at electronic page 4193. But my lord, we say, arguably, there's a greater onus on the Chief Constable to perform his duty in line with domestic legal obligations, and that in reality he's not free to resile from that commitment on Mr. Justice Maguire's analysis. We say that analysis also reinforces the argument that we advance in relation to the engagement of Article 2 and Article 3. It enforces the argument that what flowed from the Chief Constable's statement, a commitment to perform his domestic law duties to investigate crime, represents a procedural act within the meaning of paragraph 143 of Janovich, which I opened to your lordships this morning, and the electronic page reference number for that is electronic page 5093. My lords, I indicated I wanted to focus more on the issue of irrationality. What happened in terms of what the police did is summarised by Mr. Justice McGuire in the High Court at paragraphs 299 to 302, and you'll find that at electronic page 2029. He earlier in his judgment outlines in more detail what he viewed the researcher as having done, and that discussion commences at electronic page 1985 at paragraph 123 and continues until electronic page 1988 to paragraph 137. But my lords, I propose to look more closely at the police investigation, because we say that what happened was perfunctory, undermined public confidence, undermined the confidence of those who were subject to the ill treatment, but undermines public confidence more generally, and led to the conclusion ultimately that Mr. Justice McGuire arrived at, and that the Court of Appeal arrived at, is that it undermined confidence in the police service's independence in addressing this issue. The detail of the police investigation, and I am going to open some of this to your lordships, will be found from electronic page 3509 to 3525. And I should acknowledge that it comprises 2 reports. And after 3525, there are a number of appendices referred to in the second report, the second more detailed report. So 3525 represents the conclusory page of the second report. And your lordships may, in due course, wish to consider some of the appendices. But in essence, to summarise events, the RTE broadcast, on RTE for your lordships' references, is essentially the state broadcaster in the Republic of Ireland, the equivalent of the BBC. That documentary, The Torture Files, is broadcast on the 4th of June 2014. The policing board meeting takes place on the 3rd of July 2014. The researcher produces a first report following a visit to Kew, dated the 10th of July 2014, and for your reference, just for the date, you will find that at electronic page 3510. He produces a further, more detailed report on the 18th of August 2014, and the reference for the date is E3525. And on the 27th of October 2014, Assistant Chief Constable William Kerr writes to Mr. McGuigan's solicitors, indicating that no further investigative leads have been found, essentially, and that no further investigation is to take place. And that can be found at E3717. And we say what was done, both in terms of the time and resources that were put into this investigation, is that it was desultory and perfunctory in the extreme. It evidences little, if any, rigour on the part of the police service in Northern Ireland. To describe it as professional, which it was described, I think, by my friend Mr. McGuigan yesterday, is, we say, to stretch professionalism beyond the bounds of elasticity, particularly given the seriousness of the allegations and the political level at which they were directed. Now, these issues are the issues about whether Lord Carrington had authorised, and the language of torture, we say the language of torture in this sense, in terms of these submissions, is in some senses irrelevant. The issue was the authorisation at political level of the 5 techniques, because that would have been a criminal act. These suggestions arose from the RTE documentary, as I've indicated, and we say that when one looks at the research that is conducted, and again, the word research is to stretch the term, represented an abject failure to engage at all with the organisations which were identified in the documentary as repositories of relevant documents. So, by definition, the RTE, the television company, had access to documents which were potentially relevant to any police investigation, because they showed the documents on the screen, and they discussed the contents of the documents and what they interpreted those documents as meaning. The programme also credited the National University of Ireland in Galway. Research had been carried out by, I believe, their Human Rights Department. They had sent researchers to Kew and had amassed documents relevant to the issues covered in the documentary. And an NGO, the Pat Finucane Centre, had also gone to Kew and obtained documents. So there were 3 publicly identifiable repositories of documents which were potentially relevant to the issues that the police were looking at. It's quite clear that the researcher makes...
I've been waiting for a couple of minutes. And
sorry. I apologise, my lord.
Before you move on too far from what I was going to ask.
Yes, sorry.
I mean, given that the focus of the allegation and the question that the Chief Constable was asked was Lord Carrington, however important it might be considered in the interests of historical knowledge to find out about his involvement, given that what we're concerned with is criminal investigation and prosecution, it was obviously pretty futile, wasn't it? Because he died some years ago.
My lord, my understanding, and I'm subject to correction, is he wasn't dead at the time of this investigation. Your lordship is correct that he's died since, but at the time they were looking at this issue, I think I'm correct, and I apologise if I'm wrong, that he died in 2018.
All right. So, sorry, that's my mistake then.
No. I recall your lordship raising that issue yesterday, and no, to that extent, it wasn't at that stage irrelevant. I appreciate, and in fact, my understanding is that, and again, I hope I'm not wrong about this, but Lord Balneil, who's also named in the documentation, he's still alive. So I understand your lordship's point, but I don't think it was irrelevant in 2014, which was the context. And sorry for not recognising that your lordship had raised your hand. What I had been going to say is, given the allegations made in the documentary, we would suggest, and that indeed anyone would have recognised, that an obvious starting point was to engage with the organisations identified and to see whether they would assist in terms of providing relevant documents and identifying where they had sourced those relevant documents. The issue of interpretation was obviously a matter for the police, but that, we say, was such an obvious and inescapable starting point that it is extraordinary that is not the approach that was taken. And my lords, in terms of the police investigation, I was going to ask your lordships to open electronic page 3509, and this is the first report carried out by Mr. Clark, who's described as the investigating officer, and he was instructed by the historical inquiries team. And you will note, I don't propose to take your lordships to all of the all of the contents of this document, but he, I think as appears, he isolated 2 files which he thought were relevant. He was unable to find the Rees memo, which had attracted such, I think, public interest in terms of being seen as a starting point for investigation. So he was unable to source that document. And in fact, as will be seen, it appears he never sourced that document from Kew, despite the fact that it was there. But it's the language used, and this is a document. While I'm entirely prepared to accept that Mr. Clark was not a senior police officer, his reports are ultimately provided to Detective Chief Superintendent and to the Assistant Chief Constable. And so they are the people who scrutinise his report and who conclude, based on his reports, there's nothing further to see here. And I suggest to your lordships that the language at the bottom of the page, E3509, is language in terms of an investigation which ought to be carried out on a good faith basis, with a mind to exploring the issue of whether there's criminal misconduct of a senior former minister. The language is telling in my respectful submission. He said, it is of interest that the memorandum supplied, this is the bottom of 3509, infers that the government of the day authorised torture. Whoever obtained this memorandum didn't disclose various other documents which they must have had sight of when researching the subject. It is my view that when this particular document was obtained, the researcher must have had sight of the two files in question. My Lord, ultimately we'll say that the evidence establishes that the Rees memo wasn't found in these files, and so the inference that's suggested isn't an appropriate one. But the next comment, my Lords, we say, for someone working for the Police Service Northern Ireland, it is a common ploy to supply the PSNI with one item of supposed information whilst holding back on other documents which have been copied. This should be borne in mind before any decision is made as to the future conduct of this issue. Can I suggest, my Lords, that that doesn't suggest an open mind to an investigation of the seriousness in terms of its ultimate allegation with which it should be considered. And I ask rhetorically, would a fair-minded observer consider that this investigation had been approached by the police force open to investigating serious allegations of misconduct, or does it evidence hostility from the outset to those who conducted research on these topics? My Lord, the second reports are more detailed, and they commence at 3513. And I would invite your Lordships to read that document in its entirety. What I propose to do, because I recognise that the limitations in time, is to identify some aspects of the document and also to indicate your Lordship the submissions we make about those aspects of the document. Your Lordships will then read them when you have an opportunity more fully, and your Lordships can accept or reject the submissions we make in this regard. He indicates, so at 3514, he indicates in the first paragraph that he has established that the memorandum is likely to be retained at the National Archive, and he suggests ways of sourcing the documentation. It's clear, therefore, and what emerges from this page, we say, and this is one of the points we invite your Lordships to infer from this page, is that he failed at any point during the investigation to actually access the Rees memorandum from Kew. What he does do is view a copy of the Rees memorandum on a BBC page discussing the RTE documentary, but that's as far as his research gets. The second point we make is that if one looks at the third paragraph, he appears to conclude that the document was still retained and wasn't due for release until 2020. That is in fact incorrect, but that is the conclusion he draws from it, and we say that one can view his research through the prism of his inability to get to the bottom of both of those issues. And then, my Lords, we say he engages in a discussion about how the memorandum was obtained. And what we say follows from the final paragraph of page 3514 and over at the page at 3515, that what essentially he suggests is that the Rees memorandum was obtained by some underhand or inappropriate method, not by research, but by some method that's open to criticism. And I just invite your Lordships to look at 3515. He says the second publication relates to a documentary by Irish Television, RTE. It refers to alleged torture methods used during internment. He deals with what the programme's reporter stated. He notes the publication details the memorandum more or less verbatim. She is most certainly referring to the memorandum in our possession. She asserts that the memorandum was discovered by her at the British National Archives at Kew. The date of such finding is not disclosed. This in itself, together with her alleged means of finding the documents, raise interesting questions. Again, a less than neutral or dispassionate view of what the researcher was engaged in, and this in circumstances where the simple act of picking up the phone, contacting RTE and asking can they engage with the journalist about what she did or didn't do is, we suggest, less than fair-minded, if I can put it that way. And as your lordships will see, and I will invite your lordships to consider its contents in due course, Ms. O'Reilly in fact filed an affidavit in the course of these proceedings outlining the steps she took. So there's an absence of willingness to search for relevant documents, and there are pejorative comments being made about those who have accessed the documents. My lords, we then, if you go to page 3516, this documents a sequence of memos. So you have reference at the top at 1 to a statement made by Merlin Rees, Secretary of State for Northern Ireland, where he talks about the ill treatment. We have reference to a confidential letter, which I'm conscious your lordships have been taken to previously, the author being Mr. Fred Mully. And this is the document, this is in the centre of the page. He said, I've seen the Home Secretary's minute to you of the 31st of March about the Attorney General's meeting with the Irish Attorney General. I strongly suggest there should be no question about either prosecuting or taking disciplinary action against those responsible for deep interrogation in 1971. I was, however, a little surprised by the statements that our predecessors, and in particular Lord Carrington, took, and he quotes from essentially the Rees memo, a decision to use methods of torture in Northern Ireland. The published records do suggest that this is perhaps a rather hard way of putting the decision to use deep interrogation. And then you have the letter from Mr. Rees, where he accepts in the final paragraph that he compressed the record too starkly. It would have been better had I referred to the decision to use interrogation in depth in Northern Ireland. My lords, I think this is probably something that has been discussed previously, but we suggest the analysis of this exchange is that the clear issue in dispute is about the use of the language of torture at a time when the British government wasn't conceding torture, albeit that I think at this time that had been the finding of the Commission, but it wasn't about the issue of authorisation. So there was no suggestion that, and there is no suggestion, we say that this exchange of documents undermines the need for investigation, because what's been investigated are criminal acts. If they rise to the level of torture, all the more serious, but the sanctioning of unlawful assaults remains a criminal investigation. The researcher appears to accept the premise that it's about the use of language over the page. So at electronic page 3517, he says, in the central paragraph, he said it's felt that the 4 specific documents precede in the foregoing paragraphs go to considerable lengths in order to place the memorandum in context. It is perfectly clear that Merlin Rees felt he unwittingly used the word torture in an ill-advised and unfortunate manner. And then I note to the next sentence, this one memorandum has been seized upon by some groups and individuals to attempt to justify claims that the government sanctioned the use of torture. My lords, we say he accepts that the issue was one of language, but of course he seems to entirely miss the point. More importantly, so do his senior officers. The point is Lord Carrington responsible for criminal misconduct? Is that something that should be investigated further in light of the documentation that is seen? My lords, I then invite you to look at page 3519. And there's a discussion, there's an appendix K, which if I can indicate if your lordships want to look at this more closely, and I don't propose to open the documents, but it commences at electronic page E3627. And so you'll see there's a variety of documents that he look at. The first mentions the Joint Directive on Military Interrogation, that's the JIC 8515, and he notes that this would appear to be the definitive directive on matters of detention and interrogation. There are then clearly a sequence of documents which essentially deal with the treatment of detainees and give guidance to detainees. He reviews those documents, and at 3520, he arrives at a conclusion about them. He says, from the information available, it is abundantly clear that a great deal of effort and thought had gone into the preparation and implementation of these directives. They were clearly acceptable at the time and used at a juncture in history when terrorism was rife in British colonies and later in Northern Ireland. I'm going to suggest to your Lordship that that paragraph essentially legitimises and endorses the use of the techniques. It invokes no criticism, and it sits uncomfortably in a report from the Police Service of Northern Ireland. He makes references to the Parker report and the discussion therein in over that page and into the next page. He acknowledges at E3521 that the procedures were illegal by the law of England and Northern Ireland, and he then goes to observe from the majority report that Lord Parker had concluded that the Minister of Home Affairs had no idea that they were legal, and suggests that the RUC would have assumed that the Army had satisfied themselves that the procedures which they were training the police to employ were legal. Again, an attempt to essentially sweep illegality. It's not even under the carpet, just to dismiss the prospect that this is illegal conduct in circumstances where what he's scrutinising are police officers who were trained in what the law was and wasn't at the time, and who nonetheless carried out this conduct. And as we know, of course, recognised its illegality and sought assurances accordingly. He notes without, of course, at 3522, at the top of 3522, he's quoting from the Compton report, noting that the Compton report concluded that the majority of the cases involved nothing more than substantiated and uncorroborated allegations, and of course the conclusion in the next paragraph that they found no evidence of physical brutality, still less of torture or brainwashing. And he notes that without comment in relation to, he's read the Parker report, he must have read what Lord Gardner said about the definition in Compton, and yet he reports that without demur. And then at 3523, he reaches his conclusion. He says in the penultimate paragraph, on the basis of the result of this research conducted at the National Archive, I conclude that no useful purpose would be achieved by taking this matter further. The research is backed by official government documents which are clear in their intent and purpose. At no stage other than in the memorandum in question have I had sight of the word torture. He says, he then goes on to make the comment. And again, this is a report directed at a Detective Chief Superintendent who goes on to provide this report to Assistant Chief Constable. And he makes the comment, it is not clear how the reporter came upon the memorandum in question, and makes comment thereafter, which I don't need to repeat. At page 3524, he says it would appear that the media in the shape of the BBC and the RTE have used this one official memorandum to create, in the case of RTE, a particularly biased, badly researched and misleading programme. This, of course, without any engagement with the organisation who were involved in the making of the programme. And in the penultimate paragraph, he says it could be argued that the memorandum in question, the RTE programme, the internet released by Adams, which is a reference to Mr. Adams, which you'll see in the paragraphs preceding this, were orchestrated in order to achieve maximum effect. So he's now accusing the national broadcaster of engaging in a campaign of orchestration with Mr. Adams, who was probably at that stage still the president of Sinn Féin. My Lord, I invite you to conclude that the statements that are contained in the commentary contained in this report is partisan. It involves hostile, pejorative statements about those who carried out research. It essentially pitches the PSNI against those who took the documentation and pitches the PSNI against who took the documentary and the allegations arising from them seriously. And it cannot be described as professional. And it cannot, with respect in any manner, be described as the kind of investigation that one would expect to see where the allegations are made as serious as they are. I want to give you just a reference in terms of where the report went to. As I've indicated, the report went to Detective Chief Superintendent Hannah. He furthered the report to Assistant Chief Constable Harris. Detective Chief Superintendent Hannah then endorsed the recommendation made by Mr. Clark. You'll find all of that in electronic page 2091, which is an affidavit from Mr. Murphy of the PSNI. My lords, we say that the critique of those documents are reflected in the findings of Mr. Justice Maguire and indeed the Court of Appeal, both of whom are critical of the manner in which this investigation was conducted, and rightly so, we say. And we say it leads neatly into our submissions on independence. My lords, the starting point from the Hooded Men case, if we take the Court of Appeal judgment, is the Court of Appeal concluded that Article 2 and Article 3 weren't engaged. We accept there was an engagement, I think, on the first day between Lord Leggett and Mr. McGuigan about the Court of Appeal judgment in the subparagraph 9, which of course I haven't immediately to hand, but in effect it's the paragraph which indicates that, and I should get it to hand, my lords, if you give me a minute. But it's the conclusion of the judgment where the Court of Appeal essentially indicates that this document has given them cause for concern. I think is probably, sorry, my lords, it's the electronic page 1925, and it's subparagraph 9. He says, we are satisfied, well, firstly at 8, he agrees. They agree that the investigation carried out by the researcher on behalf of the HET was irrational and did not honour the undertaking given by the Chief Constable. We ask your lordships to endorse that finding. And it says, we are satisfied that the decision made by the learned trial judge to quash the outcome of that investigation was well within his area of discretionary judgment. In light of the manner in which the investigation was pursued, it seems unlikely that an investigation by the Legacy Investigation Branch of the PSNI or its successor is likely to engender public confidence. We accept that he hasn't gone so far as to say that they cannot carry it out. What he said is one has to look at whether you can have an investigation which engenders public confidence in light of the exercise that was performed by the PSNI with the involvement of officers at the level of Assistant Chief Constable. We say that the investigation could not on any analysis be described as independent or in any way befitting a professional police force engaged in the investigation of allegations of significance and gravity. The police investigation, we say, was quite properly characterised as infected with apparent bias. It demonstrates a lack of independence at common law on the part of the police service in Northern Ireland. And my lords, we simply invite your lordships to look at our submission on this issue. In our written case, it's electronic pages 4161 to 4164, paragraphs 78 to 85. We say the investigation ought to have been carried out in a manner which was demonstrably fair and impartial, and the manner of its conduct does undermine public confidence and is clearly problematic. Yes, my lords, what we say is it is clearly problematic that we're here in 2021. This investigation having been scrutinised by the High Court, having been scrutinised by the Court of Appeal, and that despite all of the institutional trappings of independence which have been described by Mr. McGuigan in the course of these proceedings, that in 2021 the Chief Constable continues to stand over this investigation as in some way appropriate or professional, as not undermining public confidence, as not being infected by apparent bias. And we do invite the court to quash it, but we note that the Chief Constable continues to defend this investigation and invites the court not to quash it. My lords, you'll appreciate in terms of the Court of Appeal judgment, this is essentially a question of practical independence. It's dealt with in the context of the common law, because that's what the court was dealing with. You will appreciate that in the course of our general submissions to the court, but both the submissions made by Mr. Southey and the submissions made here, that there are a number of routes whereby the court might conclude, contrary to the decision of the Court of Appeal, that Article 2 and Article 3 are engaged. Mr. Southey has dealt with the issue in terms of genuine connection in the Brecknell test. Our focus has been that this court can find, for the reasons we outlined this morning, that either by virtue of paragraph 143, that procedural acts have taken place within the meaning of Janovich, 144, alternatively, or as well, the Brecknell trigger has been met. And if we're correct about either of those two matters, and if we're correct about convention values, then Article 2 and Article 3 are engaged. That then raises an issue for this court in terms of whether the PSNI have demonstrated independence within that prism, which I recognise is a different prism, arguably, than that through which one might look in the common law. And my lords, I'm not sure that it would be appropriate for us to go further than simply to commend the judgment of Mr. Justice Maguire. You recall that Mr. Justice Maguire concluded, as the Court of Appeal did, that Article 2 and 3 weren't engaged. I say Article 2, my lords, because in Mr. McKenna's case, we also obviously rely on Article 2, ECHR, as well as Article 3. But he concluded that Article 2 wasn't engaged. He went on then, as your lordships know, obiter, to address various issues, including convention values, genuine connection, and also whether or not Article 2, Article 3 independence had been established. He deals with that at electronic page E2025. Yes, E2025. My lords, he puts the matter in context at E2024, and it may have some relevance to the issue and concern that my Lord Legate raised about the focus of the investigation, because your lordship is quite right about the focus on Lord Carrington. But what if I invite your lordships to look at? I invite your lordship to look at the entirety of what Mr. Justice Maguire says on independence. But it starts at E2024. He says at the previous paragraph, the end of paragraph 277, the question which arises is whether this compromises the requirement of independent investigation, assuming that such a requirement must be met. He says, in considering this issue, the court considers that it should view the matters which fall for investigation broadly and not narrowly. So he said it might be suggested that investigations which concern alleged unlawful conduct of those in government doesn't present a difficulty for the PSNI, as there's no hierarchical link. But he said this isn't an approach which commends itself to the court, given the wider historical perspective which has already been subject to the discussion. He says the better view in the court's mind is that it is difficult to do other than view the circumstances in the round. If this is done, it appears that at least a substantial extent, those involved at the time had a common purpose. So it would be artificial today to seek to draw a rigid distinction for the purpose of an investigation between those who directed the use of deep interrogation, both in London and Belfast, and those who were actually engaged in the process of implementing what was directed. A single investigation should embrace both aspects. So that was what he envisaged would happen. And at paragraph 283 at the bottom of the page, he says, in his view, there is a likely breach of the independence requirement if the PSNI decide itself to investigate the case. And he identifies his reasoning on page 2026. And my lords, it's quite clear that some of the matters he identifies are institutional and some of the matters are practical. So he talks about the fact that that the RUC were extensively involved in the interrogation. There are officers of the RUC who might still be serving, but also such officers may have served with officers who may be charged with investigation. So he is clearly raising issues of institutional independence. He also raises issues around public confidence related at C to institutional independence. Again, his position at D seems to overlap with institutional independence. At E, he addresses the issue of the position of the PSNI in dealing with legacy cases generally, and he says it has been the subject of substantial question marks in recent years in many cases long, postdating the approach of the Strasbourg court in Brecknell. And he says that in those circumstances, the level of scrutiny required and the identity of the scrutinizer against this background requires heightened care. To investigate the power, to investigate in the hands of the PSNI in these circumstances is concerning. And then he refers to public concern about the quality of investigations into troubles-related deaths generally. And then he makes the point, which is the one that the Court of Appeal picks up on, which is the investigation carried out in 2014 does not inspire confidence for the reasons he contends. So, my lords, if you were with us in relation to some of the convention arguments, we would rely in relation to independence on the judgment of Mr. Justice Maguire on that issue, and I don't take the submissions further than that. My lords, I was going to ask, when you're looking at the issue of the police investigation, and I say this and I'm conscious of the observations that Mr. Justice Maguire made, but I would invite your lordships to look at the affidavit of Ms. O'Reilly, which commences at page 2176 and concludes at page 2189. Your lordships may have appreciated that Mr. Justice Maguire felt that he didn't want to engage with that affidavit because it was drawing him into a conflict, as it were, between Mr. Clark and Ms. O'Reilly, and I recognise that, but I'm really inviting your lordships to look at it because it gives you some idea of the kind of research that could have been engaged in, the kind of engagement that could have happened, and it goes to the issue, and we only invite you to look at it in relation to the issue of the adequacy of the investigation conducted by the PSNI and how that might inform your lordships in terms of the issues of rationality and indeed independence. My lords, I'm conscious of the time. It had been said, I think, that I should also deal with the issue of delay. My point on delay, and I'll obviously stop and give your lordships an opportunity to ask any questions arising, but my point on delay is going to be a pretty summary one, and that is that I, in a sense, rely on what the observations Lord Sales made to made on the first day, when he indicated that if we're looking at this through the Brecknell prism, clearly the relevant date we suggest is the 4th of June 2014, and proceedings were lodged within a year of that date on behalf of both applicants. Alternatively, one might say that the relevant date, if we're looking at a procedural act, is the 4th of July 2014, which is a later date than the date of the RTE programme, again, well and comfortably within the year. And it appears to us, in many ways, if some of those issues fall away, the issue of delay is not going to be determinative of this case one way or the other. So those are my brief observations in relation to delay. And I'm sorry, I know I have rushed through matters, but if your lordships have any questions, and unless you do, those represent our submissions.
I don't see any questions coming forward, Ms. Quinlivan. Thank you very much indeed.
Thank you.
So, James.
For the temporal issue, I'm going to make some submissions about that, the bulk of them. Then I'm going to deal very briefly with convention values, and I've got 3 short points in relation to the Brecknell threshold and hooded men. So the temporal issue first. And it's as well to be clear about what it is that the respondents, and in particular Mr. Southey, are now contending for in this case. Their submission, as I understand it from their oral submissions, is not simply that the critical date must be the same in both Strasbourg and the domestic courts. It is, as he put it, that there is no basis for importing the genuine connection test into the HRA analysis at all. So there is a whole-scale rejection of the genuine connection test as applicable or analogous in the HRA context. And that's obviously a much more radical submission, which I will seek to address. The first point I should note is that in the Finucane case in the Supreme Court, our submission is, as you know, that the court there considered and decided that the principles derived from the ECHR jurisprudence, Silic and Janovic in particular, should be applied here. That was, of course, a unanimous judgment of the Supreme Court. And it's also clear from the judgment that that point, at least, was specifically considered. In other words, whether the Grand Chamber approach in Silic and Janovic had been or should be applied in the context of domestic law. And on day one of this case, I accepted orally, in answer, I think, to a question from my Lord Legate, that there hadn't been a detailed argument about whether, if the genuine connection test were to be applied over and were appropriate to be applied in the HRA context, the date should be anything other than the HRA date. But I did not and do not accept that the base issue about whether or not the genuine connection test should be applied at all was not the subject of argument and decision. It plainly was, as you see very clearly from the reasoning and conclusion of the unanimous Supreme Court at paragraphs 111 and 112 of the judgment in Finucane, 4713 to 4714. I'm hoping I've added +1 correctly. It's also to be noted that the suggestion by Mr. Southey that the court was dealing in Finucane with the genuine connection issue, as it were de bene esse, or as some form of obiter analysis, is plainly wrong. That is not the way the judgment is put. It is not the way the judgment is structured. There was a clear decision after argument that these principles should apply by analogy in the domestic context, and that was the decision of the court, and had been, as they found in Finucane, key to the underlying reasoning in McGuigan. It's also clear that that decision, based on the conclusion that the critical date should be the date of the HRA, and that was consistent with approaches in earlier Supreme Court cases, as I indicated in opening. And on that basis, the court held, having considered the facts and the length of delay in particular, that there was a genuine connection on the facts. So that's the first point. I turn then to the proper interpretation of the Human Rights Act, and a number of points to be made in relation to that. First, it is clear that it was not intended to be retrospective. That is evident from section 22(4). There is, in any event, as Lord Sales has pointed out on a couple of occasions, a presumption as a matter of domestic law that legislation is not to have retrospective effect, at least unless there's a clear indication to the contrary. And here there isn't merely not a clear indication to the contrary, but there is a clear indication that was precisely the intention. See section 22(4). It's also evident that there are and have been real concerns about the possibility of the Human Rights Act applying retrospectively. That was no doubt why the provision was included. But there are clear concerns about that, evidenced by almost 2 years of, in effect, transitional period between enactment and commencement. And as you will recall from the McKerr case and the speeches of the House of Lords there, Lord Roger, at least, had plenty to say about the absence of transitional periods in the Human Rights Act. So the first point is that it was clear that it was not intended to be retrospective, and retrospectivity in the context of the HRA was and has always been perceived to be a significant issue. Second point is that there is a very specific issue that arises in the context of the case or cases before your lordships. And that is because it's clear that the death itself or other triggering event is not itself covered by the HRA if it occurs before the HRA commencement date. And no one argues to the contrary. But that is, just a note, at least one indication that there is no direct coincidence between ECHR rights and HRA rights, and that the mirror principle is limited. So the question arises how to treat the investigative obligation if the death itself or other triggering event is outside the temporal limit. Entirely detachable or some connection to the death is the question. And we know, this is the third point, the principled answer that the ECHR gives to essentially that question. They recognised that if the right to investigation was to be detachable, it nevertheless needed to have a genuine connection with the death or other triggering event. And they so decided on the basis of a clear principled rationale, which they took the trouble to think through and to set out. Concerns about legal certainty, concerns to find some tethering between their jurisdiction and the events being investigated. And that is a proper and coherent approach, respectful, we submit, of the limits of their jurisdiction under the instrument which defined and conferred that jurisdiction. And it's helpful to look at the rationale for the genuine connection test and the identification of the critical date, because we submit it explains why this court has taken the approach that it has in the domestic context. So if you just go very briefly, if you would, back to Janovich. I want paragraph 128 of Janovich, which is 5089 or possibly 90. But you'll see when they start addressing 5090, I think if we do the +1, you'll see at the bottom of the page general principles. The reason for going back to that passage is because there in the following paragraphs, the court specifically grapples with the consequences of detaching the procedural obligation. And they identify two concerns. The first, and we see this in 128, is the principle of non-retroactivity codified in Article 28 of the Vienna Convention on the Law of Treaties. And the second, and we see this from para 133, is the principle of legal certainty. And it's those principles that lead the court to emphasize that the court's temporal jurisdiction as regards compliance with the procedural obligation in Article 2, quote, is not open-ended. And so their first conclusion is that there should, in principle, be a tether. And the tether is the genuine connection test. So once they've decided that, they then have to design the test. And they didn't do that very specifically first time round in Silich. That was a subject of criticism in McGuigan. So they came back to it and they designed it or refined its design some more in Janovich. But the components of that test as so designed are founded on the principled underpinnings for it. So at 141 of Janovich, to go back to those paragraphs and following, they set the criteria for the test. Firstly, in 141, where the death occurred before the critical date, the court's temporal jurisdiction will extend only to procedural acts or omissions in the period subsequent to that date. That is designed to respect the principle of non-retrospectivity, and that only works if the critical date is the date on which the state accepted the European Court's jurisdiction to determine complaints. I'll come back to that point. But secondly, the procedural obligation will come into effect only if there's been a genuine connection between the death as a triggering event and the entry into force of the convention, in other words, the critical date. And that respects the legal certainty principle and the limit of their jurisdiction. I said I'd come back to the critical date. As the critical date, as I noted in opening, KU in Strasbourg, the Chong case, makes it clear that this is the petition date. Of course, in many cases, that's coincident with the date of ratification, in the United Kingdom's case, not. But in Chong, it upheld the majority of the Supreme Court's decision in KU. And so it may be worth just going back to the reasons, the principled reasons why the Supreme Court decided as it did. That's in the KU case, in the judgment of Lords Neuberger and Hughes, starting at paragraph 79 on EF 455. Sorry, 35, it's 4555.
I'm sorry to interrupt you, Sir James. It's breaking up. I think we've lost you altogether now.
Sorry, I had a voiceover. Am I breaking up?
Yeah, it was my voice, and I'm very sorry. The line broke up, and I didn't hear the last few sentences.
My lord, I'm so
I don't know if
sorry. I
anybody else
was giving you the references into the Supreme Court's judgment.
we got to KU.
We got to
We got
KU.
to KU, yes.
Page 4555. 4555.
4555, and it's paragraph, starts at paragraph 79. It may be 4556 in your numbering, but it's paragraph 79 where the analysis starts as to what should be the critical date. And essentially the analysis flows through from there to perhaps the key paragraph for this purpose, which is paragraph 87. And can I invite you to just read to yourselves paragraph 87? Which is why, in principle, the critical date is the date of petition. And that paragraph is interesting, and we submit telling when you can come to consider how those principles that's underpinning translates at the domestic level. We say it translates over exactly. And it's right also to note and to point out in that context the point made by Lord Hodge about the distinct reaches and nature of those against whom the rights under the HRA may be asserted, or on whom the correlative obligations under the HRA are imposed. And see, in that respect, I think it's on about the same point that Lord Hodge was making, Lord Hoffman in McKenna, electronic 4802, I want paragraph 63, so it's either 4802 or 3, but paragraph 63, and it's the line just above D on that page within para 63. Although people sometimes speak of the conventions having been incorporated into domestic law, that's a misleading metaphor. What the Act has done is to create domestic rights and so on. And then he makes the very specific point in the penultimate sentence, which I think was the point that Lord Hodge was on yesterday, about the different reaches. So we also know that the European Court, applying those principles based on those rationale, specifically confronted and decided the question whether, in relation to a death before the critical date, Bracknell, with its reviving nature, in effect trumped by creating some new obligation that could be untethered from the death. I don't go back to it because you're now so familiar with the paragraphs. But if you wanted to, and for the last time, see 141 of Janovich, 5092, and 144, the critical passage, which makes it clear that genuine connection has to be satisfied even in the Bracknell context. And that was the passage with which Mr. Southey simply didn't engage. But it makes clear that this requirement, this tethering, applies also in the context of the Bracknell obligation. So the European Court's approach is that the procedural right in question has three features. First, it may be detachable, but secondly, for the principal reasons gone through, it must still be tethered to the death or other triggering event through the genuine connection test. And thirdly, when designing the tether, there are cumulative requirements, including the reasonably short period between the death and the critical date, defined by reference in the context of the ECHR to its own jurisdiction. And those features define, or if you prefer, are conditions to, the right itself. So that then is the essential context, the principle against which the HRA falls to be interpreted. One comes to the HRA provisions themselves then, the critical question we submit isn't whether there is an act or an omission. It is whether or not the act or omission is compatible with a convention right. The act in question is an act that is unlawful under the HRA because it would breach a convention right. And we know full well what that doesn't mean, that is convention right. It doesn't mean simply that you're able to make a claim in Strasbourg. That was made absolutely clear by Lord Hoffman in the passage we've just looked at in paragraph 63 of McKenna. And that means it's entirely acceptable and principled and constitutional to acknowledge that the Human Rights Act was our own bespoke solution to the introduction of certain, brackets, but not all, ECHR rights domestically, with its own jurisdictional reach and the conferral on the courts domestically in relation to, of jurisdiction in relation to those domesticated rights and obligations. We also know, nevertheless, that under the Human Rights Act, you are obliged to take account of the jurisprudence of the European Convention on Human Rights, and to be recognised that the ECHR right in question is the procedural right in the context of a death before relevant jurisdiction was conferred. And so by operation of section 2.1 of the HRA, the domestic courts in the UK have now, in line with Strasbourg's jurisprudence, recognised the detachability of the procedural obligation. McGuigan, Finucane, but those same authorities have also recognised that in cases where the death occurred before that critical date, the right arises, just as in Strasbourg, only subject to the Janovich conditions. It isn't every death that must be investigated, it's simply ones which have the relationship defined as a genuine connection to the critical date. So whether you say they're conditions to the right arising or they define the nature of the convention right matters not. These are principles that govern the content of the convention right. And in this situation, the procedural obligation therefore simply does not arise unless that genuine connection test has been established. That test is part and parcel of the detachability principle. In cases where the death has occurred prior to the critical date, you can only detach if there is a genuine connection. And if that condition is not satisfied, the procedural obligation doesn't arise, and for the purposes of section 6 of the HRA, you have no convention right. And the problem with my learned friend Mr. Southey's analysis, ultimately, is that he wants the detachability principle, but without the tethering that is regarded, for reasons that are equally applicable to the HRA, as integral to it in this sort of case. In other words, without the genuine connection test. And there is no basis for splitting those out. There is no logic for the European Court insisting on Bracknell plus genuine connection test and a domestic court not doing the same. The ECHR has incorporated that test into detachability, and it's hard indeed to see why the domestic courts would not and should not do the same, especially when it is recognised that the jurisdictional issues being confronted are essentially similar, if not materially identical. So that then leaves the question of critical date, a distinct question. It's a distinct question because it assumes that the genuine connection test has come over. The question then is what the critical date should be. And so far as that is concerned, we submit first that in the domestic context, the Human Rights Act is the key instrument conferring new domestic jurisdiction on the courts to enforce newly domesticated rights, as Lord Hoffman explained. Public authorities, to maintain that distinction between public authorities and state responsibility, should not be held responsible for deaths that occurred prior to that date, i.e. the date when the domestic court acquired the jurisdiction to find unlawfulness. So 2/10/2000 is the analogue to the date of individual petition under Strasbourg for obvious reason. They're doing the same thing. But secondly, it is also evident, we submit, that retrospectivity concerns attached to the HRA. General principle against retroactive legislation, section 22(4) of the HRA, 2-year transition period, and those concerns, the sorts of concerns that would otherwise underpin the operation of an HRA stretching back without that sort of control, have been commented on relatively frequently, including I won't turn it up, but by Lord Brown, I think in the passage that my Lord Sales drew attention to in paragraph 100 of McGuigan, 4766, and by Lord Kerr in KU at 253, para 253, 4597. That was the passage I took you to earlier on in my opening about parity of reasoning. So the concerns that existed were not just reflected in the 2-year effectively transitional period, but the concerns were about the whole range of convention rights effectively and potentially being retrospectively enforceable, stretching back to 1966. And so what we see here is the domestic courts applying the principled approach from the ECHR to the different context and dates of the HRA. They may not be bound to do so, but that is a proper and principled approach, we submit, when one considers the principled rationale for the ECHR approach. So that's the temporal value, that's the temporal issues. Convention values, very briefly, if I may, 3 short points in relation to that. Ms. Quinlivan, firstly, did not appear to take issue with the basic proposition of principle that the focus of convention values is at least apt in principle to include not just the nature of the treatment in question, but the examination of the issues in the past by authorities and courts. If there was some suggestion to the contrary, as there might have been, at least, not entirely clear, but if there was some suggestion to the contrary by reference to Janovich 143, worth just having that before you, 5094, so 143 of Janovich, she said supported or might support such an approach. We submit shortly that that paragraph provides no support whatever for there being, as it were, a preclusion under the convention values test against taking into account consideration by authorities and courts in the past, as opposed to simply confining it to the nature of the and quality of the treatment concerned. And the reason for that is because that paragraph, 143, was not concerned with convention values at all. They are dealt with from para 149 in para 149 and following, as you see from the title above 149. All para 143 is doing is to emphasize and to draw the distinction between process which is within the scope of the procedural obligation under Article 2 on the one hand, and what they describe in the final sentence of 143 as being inquiries into historical truth on the other. And I think that's the reference that my Lord Legate asked for yesterday about where historical truth was to be found. I think it's in that paragraph, it may be in other places, but it's there too. But that's all that that paragraph is doing. So it is highly relevant, we submit, is the first point, that there have been and were extensive and detailed investigations at the time, including by independent people, questions in Parliament, and most importantly, 3 rounds in Strasbourg. Secondly, so far as the nature of the treatment is concerned, and Ms. Quinlivan's submissions in relation to that, I simply reiterate that as Janovich 151 makes clear, page 5095, the grouping of the types of claim, war crimes and so on, was selected, as is evident from that paragraph, on the basis that those sorts of conduct attracted no limitation, effectively no limitation under international law. And that serves to delineate the nature of those groups. Thirdly, Ms. Quinlivan spent a considerable amount of time suggesting that the treatment involved in the 1970s in these cases would now be regarded as torture. And my submission in relation to that set of submissions is that they are, and that inquiry is neither relevant nor appropriate. I do not, I make absolutely clear, seek to attack the living instrument doctrine. The fact of the matter, however, is that the characterization that was placed on that conduct in the societal and legal state in the 1970s was conclusively determined by the European Court in its judgment in 1978. And the European Court has now refused to revise that finding in the modern era. It would be inappropriate, we respectfully submit, and does not advance the protection of the core values that the Convention espouses, for the domestic courts in those circumstances now to see, my Lord Legate, I'm sorry.
I was just going to ask, Mr. Eades, surely for the question of applying the Convention values test, when we're looking as to whether we can go, how far back we can go, we do have to apply the standards of now, don't we? We can't go back and ask ourselves, well, was this okay in 1940 or something, or 1960 for in Malaysia? We surely we do have to apply, in asking how far back we can go, the position as it would now be seen.
Well, my Lord, if that question asks, is that a current question? I agree. My answer to that is yes, it is. My point is that in answering that question, you are entitled to see that the Convention is a living instrument, that the values it espouses may change over time, that the court has already ruled on that in the late 1970s and has come back at it and refused to reopen it. And the question is whether it is necessary for the purpose of protecting the Convention values for this court now to do what Strasbourg effectively declined to do as integral to the Convention values test. And my submission in answer to that is that it isn't. So that's how I put it. Lord Silence, yes.
I just wanted to check on a technical question in relation to paragraph 151. The Convention Against Torture requires, I think, states to criminalise acts of torture. But is that subject to the imprescriptibility which is referred to there? Can you tell me?
I can't tell you that off the top of my head, I'm afraid.
Well, perhaps if that could be.
Can I check that and make sure you get an answer at some point to that? I will check that.
Yes, because I mean we do have an international convention, the UN Convention Against Torture, the 1984 Convention. I think I'm right in saying that it imposes obligations on states to criminalise torture, and the question is just: is that are they left with the option of criminalising just for the future, or is it?
Is it back to the past as well? I'll need to check that if I may. I see the question.
Thank you.
My Lords, finally on this third point, or two things to finish this point perhaps. Firstly, of course, none of this stops anyone, Strasbourg or domestic courts, were inconceivably the same sort of treatment to be meted out today. No, nothing would prevent anyone from ruling on how properly to characterise that sort of treatment as of today if it arose as a current issue. I also wanted finally to remind you in relation to the revision judgment itself. My learned friend Miss Quinlivan said, well, that supports the position that she was taking. I think she took you to 124, para 124 of that revision judgment. Give me 1 second, I'll look at the page. It's page 5030. And all I wanted to do was to note, or invite you to note, that having set out in 124 the uncontentious position in principle that is there set out, the court went on in its concluding paragraph on this very issue, which is whether or not the new facts would have been or were of decisive influence, see the title above 119, they went on to conclude that section in 135 on page 5032, bottom of the page, as you see there. So 124 and its statements do need to be read with the way in which those principles and that approach actually played out in the context of the decisive influence analysis of the court in 135. Finally, if I may, on the Brecknell test not being satisfied in the hooded men case, 3 short points to finish, and then I'll hand over to Mr. McGuigan. Firstly, the new material we submit that has come to light since the 70s is not capable of opening up new investigative opportunities or undermining previous conclusions. The respondents have known since the 70s that the 5 techniques were authorised at a high level. The fact that it's now clearer in the light of further evidence that there was ministerial authorisation is not new information. It's entirely consistent with the prior knowledge that this was authorised at a high level. This is therefore exactly the same kind of case as Chong or KU in Strasbourg, where there was already weighty evidence in the public domain that challenged what had been the official count of the killings in that case. And as the European Court put it at paragraph 93, C4859, when further evidence came to light, they found that the material, quote, merely corroborated the account that the applicants had always believed. So the Court of Appeal was right in this case in Northern Ireland to say at 105 of their judgment that the new material does not alter the substance of what has been known for the last 40 years. In any event, that ministerial authorization was believed to have occurred by the hooded men, even at that high level, and that high level meant ministerial, appears tolerably clear from the civil claims that were made, at least in 2 of the cases. I won't invite you to turn them up now, but Mr. Shiver's civil claim against the government in 1972, paragraphs 13 and 14 allege that the Minister of Home Affairs in Northern Ireland had approved the procedures, paragraph 3, and paragraph 3 refers to the 5 techniques. So 13, 14 and 3 of that claim, 2641 in the electronic, and the same point in the Montgomery civil claim in 1974, 2656, paragraph 11 requires the defendant to admit that the minister knew of and approved the techniques in paragraph 3, i.e. the 5 techniques. So in both cases, they at least believed that high level meant ministerial level. That's the first point. Second point, and related, is that the European Court's conclusions in the revision judgment plainly irrelevant to whether the Brecknell test was satisfied. Mr. Southey made a number of points about how the European Court was applying a different legal test. And of course, it is right that they were applying a different legal test. But the significance of the judgment is in their assessment of the import of the new evidence. And that assessment was in general terms, including analysing whether or not material was unknown to the court and could not reasonably have been known to the parties. And you see the conclusions, you'll remember the conclusions that they reached at paragraphs 115 and in particular 118. In any event, the Court of Appeal in Northern Ireland did not simply rely on the revision judgment. They conducted their own analysis, as you see from paragraphs 103 to 107. And thirdly and finally, we do submit that the kind of inquiry sought in any case falls well outside the investigative duty under Article 2. What is in truth being sought is precisely the sort of inquiry which the Strasbourg Court referred to at 143 of Janovich as an inquiry into historical truth. And that doesn't fall within the reach of Articles 2 and or 3. And again, there is an analogy with KU here. The Supreme Court in that case held that the remedy sought in that case fell outside the Article 2 procedural obligation. And one can probably take it most conveniently from the European Court's summary of our Supreme Court's reasoning in that respect at paragraphs 67 to 68 of Chong, EF 4851. To which we say mutatis mutandis here, if I'm allowed to finish with Latin. So, my lords, those are my submissions in reply. Unless I can seek to assist further, I'm sorry I've shot a little bit over. I hope Mr. McGuigan will forgive me.
So, James, thank you very much. Dr. McGuigan.
My Lords, I'll deal first with the submission of Mr. Southey, and then I will turn to the legitimate expectation points in common law raised by my learned friend Ms. Quinlivan. Firstly, in respect to Mr. Southey's submissions, a good deal of his submissions this morning involved commentary on matters that are properly interpreted as questions of institutional independence. The critique of the Lundy research, Her Majesty's Inspector of Constabulary reports all go to that question. So it's important to consider what was actually in issue and what the Court of Appeal decided on these points. And if I can invite you to turn to electronic 262, and you will see there paragraph 146 of the Court of Appeal judgment in McQuillan. You will see an analysis here of the impact of the Brecknell decision. And you'll see in that paragraph, the court, about 6 lines down, recognising the impact of Brecknell. At one level, the PSNI may be said to be institutionally connected to the REC as it was successor to the REC, inherited officers, so on. However, that's to overlook the fundamental and widespread reforms brought about by the Belfast Agreement. Those reforms, while not achieving a complete institutional disconnection between the PSNI and the REC, were sufficient to achieve institutional independence. That was the impact of the decision of the ECHR in Brecknell on the question of institutional connection. And dropping down a couple of lines, it's clear on the basis of the reforms that have taken place and the evidence then available, the European Court was satisfied those reforms had achieved institutional independence. That's the Court of Appeal's assessment of the institutional independence point. It dealt with it and it found that there was no institutional independence failure. Now, my learned friend Mr. Southey's submissions today touched again and again on issues that go to the question of institutional independence. However, the court will note from electronic page 88 that the respondents put in place a very limited cross appeal in this case, dealing only with issues in respect of the common law and matters relating to the Code of Ethics. So there was no cross appeal in respect of the Court of Appeal's findings on the Brecknell point, even though submissions have been made to that effect in the course of the hearing. Now, the respondent has presented a somewhat equivocal written case on the question of institutional independence. If the court looks to the written case on behalf of Mr. Southey's client at EF 4093, you will see that the case is maintained that the Court of Appeal held that the LIB did not meet the requirement of independence without disaggregating between practical and institutional independence. But at 187, that's page 4101, and 188, paragraphs 188, you will see that it's more clearly expressed that there is a challenge to the findings in respect of the Brecknell institutional independence point. So the point is put in play. Sorry, my Lord Leggett.
Well, I think it was taken out of play by Mr. Southey, unless he's going to say something different, because he made it clear, or I understood he did, that whilst it may be his client's position that there was no institutional independence, it's not something he can argue or does argue on this appeal. He was limiting the point, as I understood it, about the backward progress, as it were, since the ATP was disbanded, to the background against which one considers this particular case, but not as a structural, suggesting a structural flaw that infects the whole institution.
Yes, Lord, that intervention is helpful insofar as the what
Sadly will leap in now if he didn't say that, but I thought it was pretty clear that he did. That's how I'm proceeding anyway.
And that's the way the court should proceed, my Lord, because in our submission, what follows from that and what follows from an analysis of the Court of Appeal judgment, that the only issue in play on the independence front is the question of practical independence. That is the issue that is before the court, given the findings which the Court of Appeal made in that regard. And that in itself, I think, exposes one of the difficulties with the Court of Appeal's judgment. It is somewhat opaque as to what exactly it was addressing, but we say it can only be the question of practical independence. And the difficulty here is that if Brecknell applied, which it did and had to be applied, and the court accepted that, then the question of practical independence is in this case being assessed not against an investigation, not against individual officers, but against an institution, the LIB, at the outset of a process before it's taken a single investigative step. And that, we say, is the fundamental flaw at the heart of the Court of Appeal judgment in McQuillan. That, of course, when one looks to see in the Hooded Men judgment how the analysis bears out there is no detailed analysis, because that finding is simply lifted across and imported in paragraphs 47 and 71 of the Court of Appeal decision in the Hooded Men case. So it is a helpful analytical exercise driven by the way in which the case has been presented to narrow the issue down to what is actually in play in the Court of Appeal's determination. So it is, we say, only a question of practical independence. Turning to the analysis on those points, my learned friend Mr. Southey engages with the Grand Chamber Authority in Tunk, and of course I've already acknowledged that wasn't opened to the Court of Appeal whenever it was giving its determination. But a number of points are taken from it. I see we've lost one of the participants, Lord Lloyd.
Thank you very much, Dr. McGuigan, for noticing that. I was scribbling at the time. We'll have to wait till he comes back. Lord Lloyd Jones, we lost you for a second. Can you hear us now? We can't hear you.
Sweet.
Yes, it's exactly the same. It's been breaking up.
So,
It's lost again.
back on.
Well, we can hear you.
Yes, I've not been able to hear. I can hear you now, but I've not been able to hear you for the last minute or so.
Well, just by way of summary, Dr. McGuigan responded to Lord Legate's question.
I have that, and I have it up to only practical independence is in play.
Yes, well, you've only missed, in fact, the equivalent of a sentence, which was that my learned friend engaged in the Grand Court's judgment in Tunk, and we were going to go and look at Tunk.
Thank you.
Dr. McGuigan.
Thank you, my lords. Yes, briefly, Tunk's important, we say. It's a key case. It deals with one of the central issues here, practical independence and public confidence. One of the issues that was touched upon by my learned friend was the issue of inertia in investigation, and it is recognised that there is a significant caseload in respect of legacy investigations in this jurisdiction, significant and growing. But inertia is, we say, a concept that betokens some sort of willful actions on the part of the authorities to prevent investigations taking place. The issues in this jurisdiction are resource driven. There is a very large number of cases. There is a police service which has been reduced in size by the patent reforms to just over 7,000 officers, not whom all of whom are on duty at the same time, of course. They're dealing with a state of terrorism that has been severe since 2009, and there are many priorities for the Chief Constable to address. He does not control his budget in terms of its size. That is a matter that is determined by the Department of Justice under Section 9 of the Northern Ireland Act, or Police Act 2000. My Lord Legate, I see your hand.
That may be relevant up to a point, because obviously that was relevant to take account of priorities and so forth, but is a limit to how much that could be used as a defence to Article 2, isn't it? I mean, the position may simply be that if not enough resources are provided, the public authority is unable to fulfil its obligation, assuming for this purpose that there is one. One can't just say, oh, well, he hasn't been given enough money, and so as long as it takes, that doesn't count as delay.
My Lord, I would tie this point to the Osmond duty and the observations of Lord Sales yesterday, which is also imported into the Brecknell decision, because the Chief Constable can't expand his judgment, his budget. I accept that. He can prioritise within his budget as to what he spends the money on, quite properly. And what Osmond says is, even in the Article 2 context, you allow a degree of latitude to the police service as to how they decide to deploy their Article 2 resources. And Article 2 has an impact in the present day in terms of substantive protection in ordinary policing, and it has an impact in its procedural context. And the Chief Constable has decided to apportion it in a particular way. If there's a need for a greater devotion of resource by the state, that's not a matter for the Chief Constable. That's a matter for the state, we say. So it doesn't follow that because there are delay constraints, there are resource issues, it doesn't follow from that that there is a practical independence problem. We say those points don't connect at all. And you'll see that, my lords, from the letter which I think Mr. Southey quoted in 2015, when the Chief Constable realised and was told the Stormont House Agreement had been enacted and that the historical institutional HIU body was being brought into play, he wrote to the policing board and he said, I don't have enough resources to do this work. The LIB will do it, but I have challenges to meet. And that document has been open to you several times. It's electronic 1118, where he wrote immediately, raising the issue of the challenges that he faced in terms of delivering on those points. So inertia, we say, is not the correct concept to apply here. There are resource constraint problems, but that doesn't go to questions of practical independence. And there are issues there that can be addressed by other state agencies. But I say all of that within the frame of reference of the general Osmond duty that it has been directly recognised in this context in the Article 2 jurisprudence. My lords, some weight's been laid on the Porter-McGill test, understandably. The court has heard submissions on that from both parties. My learned friend Mr. Southey opened to the court and made reference to the decision of the House of Lords in Duffy, which is a decision of 2008. And it was put forward as an example of Porter and McGill being used outside the tribunal courtroom context, in other words, at a wider frame of reference and scope than simply in bias in tribunals. Duffy is at 4661 of the Book of Authorities. And Duffy, you will see from the headnote, is a case about the Northern Ireland Parades Commission, which when it was set up had two individuals appointed to it who were members of one of the organisations that was most frequently involved in public controversy about parading, and their involvement was challenged. Their appointment by the Secretary of State was challenged, and Lord Bingham gave the judgment on the point, and he recognised at page 4670, paragraph 25, that the Commission is not a court, and its procedures and rules are not a court, not those of a court. He recognised these are not judicial tasks, but their tasks can only be performed by a body which is accepted by both parties as independent, objective, impartial in its approach. And he goes on then to note that there will be practical difficulties if two individuals for whom recusal will constantly be sought are among the narrow cohort of commissioners in order who can sit on these cases. And you will note at the top of page 4671, his observation at A, no reasonable person, knowing of their background and activities, could suppose that either would bring an objective or impartial judgment to bear on problems raised by the parade in Portadown and elsewhere. And at the bottom at E, you will see that he comments on the recruitment of two hardline members of the very lodges whose activities have been the focus of the serious problems that have caused the widespread disorder and led to the establishment of the Commission. Properly understood, this is not a Porter and McGill case. Indeed, Lord Bingham doesn't refer to Porter and McGill at all. This is a rationality decision against the Secretary of State for appointing individuals to a commission whose background and involvement in the very disruption and disorder would have made the work of the Commission inoperable, pointless, and it's a rationality case. So we say that doesn't really support the idea that Porter and McGill can be read as a sort of free-ranging, ambulatory concept. My learned friend also relies on the decision in Lawal, and that's been open to the court. And Lawal, of course, is an employment tribunal type case, and you'll find that at the relevant passage that was cited to you, it's electronic 6294. And my learned friend, Mr. Southey, refers to paragraph 14, which is at the top of that page, it's 6294. And he cites a little passage in the middle which says public perception of the possibility of unconscious bias is the key. That's from Lawal. But if one actually looks to the preceding text, and this is the text that's used to suggest that the common law and the convention are in the same place on all of this, you'll see that these again are all Article 6 authorities. These are authorities about the appearances of the actions of courts. So the focus again is in the adjudicatory paradigm in respect of courts and tribunals. What we say is significant is that there isn't a single case anywhere that's been cited to this court or to the Strasbourg courts involving the application of a Porter and McGill type test to a police service, certainly nothing domestically. And the one relevant authority which we've identified, very relevant authority, is TUNC, looking at the application of the same kind of public confidence test in the Article 2 procedural context. And we say it runs entirely against the submissions which my learned friend seeks to advance. So, in other words, we say that the authorities cited in support of this approach are not of assistance, and we say that the Court of Appeal was wrong to reach the conclusions it reached on the applicability of Porter McGill and the idea that it was some kind of analogue with the convention standards, because we say that is confounded by the decision in TUNC. My lords, turning to the question of legitimate expectation, I'll deal with this briefly. The backdrop and the focus of my learned friend Ms. McQuillan submissions was again understandably on the controversy in respect of the torture allegation. It's worth noting in passing that in the commission proceedings in the court in Strasbourg in the original Ireland versus UK case, that the UK government did not contest torture. You'll see that at paragraph 152 of the UK and Ireland case. You don't need to open it, but the reference is page 4916. So a lot of those historical documents need to be read with that in mind. The Commission made a finding in respect of torture. The United Kingdom government itself did not challenge that finding, but the court of its own motion went back over the issue in 1978. The legitimate expectation point, it's been suggested that an expectation has been raised. We say in form it was no more than a paraphrase of the statutory duty to investigate, and it's been said that it wasn't resiled from. Well, I think my learned friend actually opened the letter at electronic 3717 of October 2014, written by the Assistant Chief Constable, Mr. Kerr, where essentially he said, we've conducted our investigation, or we've conducted the research, it's been reviewed by the Historic Inquiries team. They haven't identified any evidence to support the allegation that the British government authorised the use of torture in Northern Ireland. So we say that's not a formal resiling from the commitment, but it's a statement that within the parameters as they understood them, the exercise had been conducted and discharged. And the court will note from that letter the reference to the Historical Inquiries team. The Historical Inquiries team, as you will know from our submissions already, was disbanded at the end of 2014. If there is to be more done by the PSNI in this context, it will not be done by the Historical Inquiries team. It will be done by the Legacy Investigation branch. And in that regard, it's probably worth looking at the affidavit sworn in respect of these matters by the relevant police officer, Mr. Murphy. And you'll find that at electronic 2087. He, under the heading Inquiries made by the Historical Inquiries team, sets out how that task was done. And in paragraph 7, he sets out why it was the London-based HET team which did this work, because they had experience in conducting the exercise in the National Archives. So it was an archival researching exercise. It can be criticised. The language can be criticised. We don't seek to avoid that. But it was within the parameters set, we say, an exercise faithfully conducted. My learned friend has suggested that we have characterised that as improperly as a professional exercise. Of course, that's the language that Lord Justice Deeney used in his commentary on this aspect of the case at electronic 1936, paragraph 29, where he considered that this report was not written by a police officer, Mr. Clark, a member of the historical research team, and it exhibited a considerable volume of documents. He said it was proper, professional, informative document. His language, we say. Never the Lord Legate, my lord.
To be quite clear, Mr. McGuigan, is the Chief Constable maintaining in this court that report, those reports that we've been shown this afternoon, were impartial and adequate reports to discharge his duty?
Lord, we've recognised, I think in our written case, that the reports were limited in their remit, that more work required to be done, and that the PSNI have offered to do that work. And we've done that in a context where, in addition to the work done by the researcher who went to the National Archives, there are also a significant number of government documents which were disclosed by the Secretary of State. And there's an affidavit from Mr. Marsh, which deals with these points, and you'll find that at 2096.
Well, just before you go on to, I take the point about remit, but does the Chief Constable maintain that those were impartial reports?
Well, we say, I think our position in respect of that is that it was an internal comment, that an internal document that had comments that were not for general public consumption, and we don't stand over it in those terms, but it's a starting point. The material it generated was useful. Our position is set out at paragraph 185 of our written case, page 3906, and we say it wasn't unreasonable for the researcher to approach the task as he did. It contains information which sheds light on events and is broadly useful, and the Chief Constable accepts the decision to take no further action should be revisited. That's our formal position, and he's acknowledged that more information has become available in light of other research and has offered to take it forward, not with the HET, but with the Legacy Investigation Branch, the HET having been disbanded. So, Lord, I think that's our position. And we say also worth observing that the materials which have been relied upon by my learned friends are materials that have been generated by the Secretary of State's investigation or by the actions of the Chief Constable. And that's apparent from Mr. Marsh's affidavit at electronic 2096. Paragraph 3. So there was extensive research also done by counsel on behalf of the government, generating further documents which put all of this material now in context in this litigation as part of the reply to this case. And it's in light of that that the Chief Constable said, now that I see that there's more to be done here, we're quite prepared to put LIB forward to do it as a body who is equipped to do so. So Lord, that is the position in respect of the additional research, and that remains the case. The LIB are, and if permitted, would proceed to take whatever further steps are required. And again, the court will have noted that the thrust of the criticisms advanced today and yesterday are not about the prospects of the LIB investigating RUC officers, but it's really about the way in which they've gone about investigating ministerial authorisation. Ministerial authorisation in respect of ministers, all but one of whom are deceased. So that, we say, again, is an important contextual factor here. The LIB would be clearly well fit, institutionally and otherwise, to investigate the conduct of police officers. They have done that in other contexts. They would be well fit to investigate the conduct of ministers who authorised these matters in 1972. And we say the Court of Appeal was wrong to say ab initio that they couldn't take that step. Lords, those are our submissions in reply.
Dr. McGuigan, thank you very much. It now falls to the respondents. Mr. Southey, are you starting?
My Lord, I am. I just raised one issue about timing, which is that my learned friend slightly overran, possibly significantly overran the sort of proposal, the revised proposal. I will do my best to finish by 4 o'clock, but Ms. Quinlivan wants a couple of minutes, and absolutely properly. And
well, but between the two of you, we will sit till 4:05, and that is a limit.
Thank you, my Lord. Can I then deal very quickly with the temporal issue? To be clear, and if I wasn't clear, that's my fault. Our point about the genuine connection is not that we throw the genuine connection out. It is that it's applied to the Strasbourg critical date, because that's when Strasbourg applies it. The critical issue, which was not argued in McGuigan, and my learned friend fairly accepted that, is what is the critical date? If the critical date, as we say, is 1966, then genuine connection applies to that. And that's where, for example, paragraph 111 of McGuigan fits in. McGuigan says Silic decides genuine connection, but it doesn't say what, as a matter of domestic law, genuine connection applies to. And the issue comes back to the interpretation of the Human Rights Act, because my learned friend has to incorporate, in circumstances where he accepts properly in our submission, because this is the inevitable consequence of McCoy, that there are cases where there is an obligation under the Human Rights Act in relation to a triggering event before 2000, accepts that has to apply because of the detachable nature. What he seeks the court to do is imply into that principle a limitation that clearly Parliament could not have considered. And ultimately, if that is necessary, we submit it should be a matter for Parliament. The objections or the policy reasons that underlie the European Court of Human Rights, the risk of, I'll try and avoid repeating myself, but they simply don't apply in the same way. So that, for example, legal certainty doesn't prevent Bracknell giving rise to obligations on the UK in relation to 1970s incidents. And it doesn't because of the importance of preventing impunity. And when one thinks about what that means, ultimately, because the United Kingdom seeks to comply with its obligations, the state will be required to comply. Public authorities will need to take action because the government will seek to ensure that will take action. All that will happen, essentially, if the court concludes the Human Rights Act doesn't apply in cases like the Hooded Men or in cases like the McQuillan case, is that the European Court of Human Rights will have to deal with the sorts of issues that Dr. McGuigan was arguing about resources and the extent to which resources are relevant to independence without the assistance of domestic courts. And when one thinks about the sensitivity of those issues, it seems pretty unlikely that in our submission that Parliament would have wished those sorts of issues 20 years after the Human Rights Act to be decided by Strasbourg without the input of domestic courts. And that's ultimately what the consequence will be. And that reflects the fact that my learned friend correctly in our submission says that convention rights, what is meant by convention rights, are determined in accordance with the European Court of Human Rights. In this case, as we've already indicated, there's no doubt, effectively, because they are after 1966, that the Bracknell issues in both cases would potentially be enforceable and be convention rights in Strasbourg terms. The only way in which it can be constrained is by Section 22, and Section 22, on the face of it, doesn't draw the distinction that the learned friend seeks to argue for.
With respect, Mr. Southey, this is covering ground which you have already covered. Time is tight. I do urge you to answer new points, not to repeat old ones.
Sorry, my lord. In terms of the application of Bracknell in this case, my learned friend made a number of points about that. In particular, he argued that effectively the threshold wasn't crossed. See Chong. Chong, paragraph 93, talks about material being relevant where it undermines the official account. And that is the critical point here. The new material undermines the official account. The civil claims were without effectively evidence, and indeed that is precisely why there was a desire to settle them, essentially. One thing that I should say in relation to the argument, essentially, that we want detachability but no tether, that is wrong, because, as I say, we submit that the same tether as the European Court of Human Rights applies should apply here, and that same tether is related to 1966. Strasbourg would apply Bracknell, limited by the 1966 date and the genuine connection, and that's all we're arguing for. So we're not saying there should be no tether, we're just saying it should reflect Strasbourg in circumstances where what my learned friend is arguing for, and I'm in danger of repeating myself, is obviously something different. Turning then, can I go on to one thing actually from my learned friend Ms. Quinlivan's case, and submissions about convention values. My learned friend made the point, and we don't disagree, that categorization essentially of whether this is torture or not it may be important. But we would submit, and we make this clear in our statement of case. Given time, I'm not going to take you to it, but it's onwards. It's para 153 onwards, page 4087. That if contrary to our primary argument, and we're entirely in agreement with Ms. Quinlivan about our primary argument, but if contrary to that, the court were to go where we submit it shouldn't go for reasons I'll come into, and find that this was not torture in 1971, and find that that is the date that matters for the purposes of convention values. The fact that this was degrading and inhuman treatment authorised at the highest levels in our submission is potentially sufficient, essentially, because the UN Convention on Torture, page 10110, Article 16, makes it clear that there is also a particular need to guard against inhuman and degrading treatment authorised at the highest level. And so in our submission, the combination essentially of the level of authority plus the seriousness of the treatment is sufficient to mean convention values, whether or not the torture label applies. What we would say, though, in response to the three specific points made, is firstly, in terms of the investigation, it is absolutely clear that none of the investigations that took place were Article 3 compliant investigations for criminal purposes. None of them were concerned with criminality. Quite clear, a policy decision was made, as recorded at the time, not to pursue criminal proceedings. Secondly, in terms of the submission, essentially, that made by Sir James Eadie, linking convention values to war crimes. Can I just refer the court to our statement of case at para 161 and 164, where we refer to a number of international instruments that draw sort of parallels, essentially, between the sorts of conduct in issue in this case and the sorts of conduct that were described by the European Court of Human Rights in Janowicz. In particular, Article 8 of the Rome Statute criminalises torture as a war crime. So it's the same level of seriousness in our submission. Thirdly, in relation to the argument about whether or not one should determine whether or not this is torture, ultimately the critical point is that the seriousness of the conduct. That conduct is obviously the most serious nature. The question really that convention values is about is whether the conduct requires an investigation now. And in that context, the findings of the High Court and Court of Appeal that this was torture have not seriously been challenged and are extremely important in our submission when looking at the that issue. They demonstrate that this is conduct of the most serious nature, particularly when combined with the level of authorization. Finally, in terms of, and I think I can respond in relation to this because we are cross-appealing in relation to common law independence. The learned friend referred to Duffy. If one looks at Duffy, paragraph 30, Lord Bingham endorses Lord Carswell. Paragraph 49, Lord Carswell applies Porter and McGill. That's why we referred to it. I think, subject to those beside me telling me that there's something else I need to say, that covers everything, I think. And I've, in fact, given my learned friend Ms. Quinlivan 5 minutes before 4 o'clock.
Mr. Sally, thank you very much. Ms. Quinlivan. My
lords, I won't take the full 5 minutes. I just wanted to deal briefly with a number of the points made by Sir Eadie, and that's in relation to convention values. Sir Eadie drew your attention to paragraph 135 of the Ireland versus the United Kingdom revision judgment at electronic page 5031. On doing so, I appreciated that I had intended to open to your lordships paragraphs 131 and 134 on the same page, I don't open them to your lordships now, but I would invite your lordships to read from 131 to 134, with particular emphasis on the contents of 134. And your lordships undoubtedly may need to read more of the judgment, but if I invite your lordships to do that without expanding on it. The other point we wish to make, I think, covers territory that my friend has already covered. So he referred to the investigations which have occurred to date. Our point is a simple one. None of them, to use, and it's important to use the language of Janovich, none of them were capable of leading to the identification and punishment of those responsible. That's what they ought to be able to do. They didn't meet that. And that passage from Janovich, my lords, is paragraph 143, electronic page 5093. And the European judgments, if I can say this, they're not relevant to your determination of this issue to this extent. The duty falls on the state to investigate. That's clear from Strasbourg. And it is a duty, the impetus for investigation, in fact, lies in the state. But also, more significantly, the Strasbourg court had no power to identify or punish those responsible, nor no power to direct the state to identify and punish those responsible. And in fact, your lordships will have seen from the papers that that was the very issue which led to the failure of a friendly settlement between Ireland versus the UK. It was that the Irish government wanted identification and punishment. The United Kingdom government resisted that, and the European Court said that's not within our power, quite properly. My lord, those are our submissions. Thank you for your time.
Ms. Quinlivan, thank you very much. We've managed to finish by the official deadline of 4 o'clock, and I'm most grateful to Council because you've had to cover a very great deal of material. The Court is grateful to Council and those who have assisted them in preparing the documents for this important case for their work in that regard, in what can only be seen as a sad and concerning time in the history of Northern Ireland and these islands more broadly. The Court will take time to consider with great care the submissions which have been put before us and will produce a judgment in due course. Thank you. The Court will now adjourn.
Thank you.